If you're studying for the California real estate exam, you're in the right place. This channel is designed to help you pass the real estate exam on your first try. I'll walk you through exactly what you need to know, no fluff. If that helps you, hit subscribe, and we'll study together. California exam prep, property ownership, and land use controls and regulations. Environmental hazards and regulations. Licensees should be aware of a variety of hazardous substances that might be present in or on properties they show, list, or sell. Licensees don't have to know how to investigate environmental issues, but should know how, where, and when to seek expert assistance. Licensees should recommend that clients engage the appropriate experts to perform interior home inspections as well as soil, air, and water tests, if indicated. Licensees should always document recommendations made to clients, particularly if a client declines environmental testing. Types of hazards.
These are silent killers. Asbestos.
Asbestos friable is a fibrous material that's dangerous when it begins to deteriorate and becomes easily crumbled or reduced to dust. It was used in many materials before the 1970s because of its fire retardant qualities. Airborne asbestos is dangerous because inhaled particles can cause lung damage and cancer.
We have asbestos in the ceilings.
The EPA and California state law regulates asbestos use, handling, and disposal. Only licensed professionals should handle asbestos. Homeowners can hire certified asbestos consultants to assess asbestos danger and for abatement procedures. No federal laws require abatement of asbestos in residential properties. Lead. Lead can be found in paint, plumbing, dust, soil, and drinking water. Lead causes many health issues, particularly among infants, children, and pregnant women. In children, lead-related issues can include behavioral problems, learning disabilities, seizures, and even death. The Residential Lead-Based Paint Hazard Reduction Act requires specific disclosures to buyers and renters of residential property built prior to 1978. These include disclosure of known lead-based paint hazards, providing an EPA-approved information pamphlet, and 10 days to conduct a lead assessment. The EPA designates homes built prior to 1978 as target dwellings because they're more likely to have lead-based paint. The federal government doesn't require lead abatement in homes, but some states do require it. The Federal Lead Renovation, Repair, and Painting (RRP) rule requires contractors who perform tasks that may disturb lead-based paint to be certified and to follow lead-safe work practices.
And we have radon.
Radon. Radon is a naturally occurring gas that can be found in soil and well water. Radon enters a home through a building's cracks and crevices, and experts believe it can cause lung cancer. Some areas of the country are more likely to have high levels of radon, but licensees should suggest sellers test a home for radon and take mitigation action if needed before putting it on the market. Buyers should ask for a test prior to completing the transaction. Homeowners can purchase radon self-test kits and send them to a lab for analysis. The highest levels of gas will be found in the lowest levels of the home, such as a basement. Results are measured in picocuries. If the home tests at or above a level of 4 picocuries per liter, experts recommend mitigation, which can include sealing cracks and other foundation or basement openings and installing a vent system. Radon mitigation isn't required by federal or California law. Quick pause. If you're taking the test soon, subscribe, so you can come back and keep studying. Okay, back to it. Mold. Mold growth is promoted by excessive moisture and lack of air circulation. Excessive levels of mold can cause allergic reactions or act as a respiratory irritant in individuals who are sensitive to it or are immune compromised. In some cases, molds may release potentially toxic substances. In residential environments, no federal regulations exist regarding mold testing or abatement. Some states have laws that govern mold remediation. The EPA recommends that an expert remediate affected areas larger than 10 square feet.
We should really have the office's air quality tested.
Carbon monoxide. Carbon monoxide is an odorless, colorless, and tasteless toxic gas that's formed from fuel combustion. Gas appliances must be properly vented to the outside to prevent buildup of carbon monoxide indoors. Improperly functioning gas and oil furnaces, gas refrigerators, clothes dryers, ranges, water heaters, and space heaters may be a source of carbon monoxide, as are automobile exhaust, fireplaces, charcoal grills, and wood-burning stoves. Initial symptoms of carbon monoxide poisoning are dizziness and nausea. California recommends carbon monoxide alarms in all single-family dwelling units. Volatile organic compounds, VOCs. VOCs can make indoor air quality toxic at high levels and may be found in some air fresheners, cleansers, paint, and building materials. Leaking underground storage tanks can contribute to groundwater contamination. A variety of federal and state laws protect groundwater. Underground storage tanks are most likely to be found in older construction and former industrial sites. The Division of Water Quality oversees California's underground storage tank program, including leak prevention, cleanup, enforcement, and tank tester licensing. If you suspect the presence of a UST, research when and how it was decommissioned. Waste disposal sites, or landfills. Landfills are typically huge, excavated areas where waste is buried underground. Federal, state, and local governments regulate waste site placement, construction, and content. Rural properties, or properties that were once in rural areas but have been swallowed up by a metro area, may also contain sites where property owners once dumped trash. Inactive waste sites are often capped, covered with soil, and ventilation pipes are placed from the base of the waste site through the cap to expel accumulated natural gases created by waste decomposition. Test wells are installed and monitored to test for groundwater contamination. Golf courses, parks, and housing and office complexes are often constructed on these capped disposal sites. Hazardous wastes are disposed of at special purpose landfills. Special purpose landfills are usually located in remote areas, away from human contact, and are subject to strict regulation to prevent the escape of toxic substances. Properties that have been contaminated by commercial or industrial use may be referred to as brownfields. The Brownfields Law, enacted in 2002, provides direct funds, mostly in the form of grants, to assess and clean up brownfields. Contaminants at these sites include petroleum, industrial waste, and even waste and byproducts from methamphetamine labs. A superfund site is one that the EPA has determined presents a potential threat to human health or the environment as a result of uncontrolled hazardous waste, and which requires remediation. Licensees must disclose the existence of a nearby Superfund site to prospective buyers. The Comprehensive Environmental Response, Compensation, and Liability Act, CERCLA, was established to clean up closed, abandoned, or uncontrolled hazardous waste sites and spills. The EPA identifies Superfund sites and is authorized to oversee the process of remediation. The Superfund's Amendments and Reauthorization Act, SARA, added an innocent landowner defense to CERCLA. Landowners who performed their due diligence when purchasing a property may be held innocent of cleanup liability if the property is found to be contaminated. Either buyers or sellers may be liable for cleaning up contaminated property. Strict liability. The property owner is responsible for cleanup regardless of who's at fault. Joint and several liability. Each of the responsible parties is personally responsible for damages. Retroactive liability. Both the current owner and prior owners are liable. If liable parties aren't doing cleanup, the EPA can hire its own contractors, do the cleanup work, and then bill the parties. California requires disclosure related to 6 types of natural hazards. Special flood hazards areas, areas of potential flooding due to dam failure, high fire hazard areas, forest fire hazard areas, earthquake fault zones, and seismic hazard zones. Licensees should be aware of environmental issues pertinent to the area where they work. Such issues may include coastal areas may experience faster decay of building materials and erosion of soil. Building may be restricted by local policies related to the California Coastal Act. Earthquake and seismic hazards are an issue in some areas, and fire hazards may require additional work from the homeowner to maintain a defensible area. Noise may be an issue from airports or highways. Private controls. Private land use controls place restrictions on the appearance or use of land by individuals or private entities as opposed to those placed by a government body. Private land use controls include easements, liens, deed restrictions, and subdivision regulations or HOA rules, including CC&Rs. Deed restrictions are private restrictions that may be placed on a deed at any time by the owner. The restrictions apply to the specific property. They run with the land, meaning they remain associated with the title and generally can't be removed by new owners. Some deed restrictions may have a time limit and will no longer exist when that limit is reached, but most stay with the property forever once created. Covenants, conditions, and restrictions, CC&Rs, are a form of private land control used in a subdivision or community. CC&Rs are typically placed by a developer on parcels in a subdivision and apply to all properties in the development or community. Covenants are agreements or promises between parties. For example, homeowners in a covenanted community may agree to abide by the community rules as part of membership in the homeowner association. Conditions are a requirement of a conveyance and create a fee simple defeasible estate where violation of the condition may result in a right of re-entry or possibility of reverter. The deed must contain phrases such as "for so long as," "on condition," or "provided that," to create a condition. State law may limit the use of conditions. A restriction limits how the land can be used. It may be a deed restriction if it appears as a clause in the master deed that applies to all properties in the subdivision. Each property's deed usually makes reference to the CC&Rs found in a master deed or declaration of covenants. The declaration is generally recorded in the land records in the municipality in which the property is located. Even though CC&Rs are not necessarily in the deed to each individual property in the development, they apply to all in the development. Typically, the CC&Rs include a requirement to establish a homeowners association. Once the HOA is formed, the declaration of covenants then becomes an agreement between the property owners and the HOA, including the obligation to pay the HOA fees. CC&Rs subject property owners to certain rights, responsibilities, and obligations. They regulate how the property may be used and its appearance. The HOA, or any member of the HOA, may pursue enforcement in a court of law if a resident isn't complying with the covenants. Doctrine of laches. Regulations that aren't enforced may become unenforceable under the doctrine of laches. The Common Interest Development Open Meeting Act says that an HOA meeting agenda must be posted at least 4 days prior to the meeting. An HOA board is prohibited from taking action on any item of business outside of a board meeting. California's Brown Act, which gives the public the right to attend meetings of local legislative bodies, also applies to HOAs. This act also prohibits a board from discussing business without a majority of members present, including any email communication. Water rights. Water rights are especially important for agricultural use or in areas where a well is needed or water is scarce. 3 categories of water rights include riparian rights, littoral rights, and the doctrine of prior appropriation. Riparian rights address water that moves through a property, such as via a river or stream. Riparian rights are classified into one of 2 categories based on the type of water: navigable or non-navigable. Littoral rights address static water, such as water in a pond, lake, or ocean. Owners with littoral rights have the right to use and enjoy the static water, but not to divert or contain it. Prior appropriation. Prior appropriation says that the first party to physically take water from a source and put it to a beneficial household, agricultural, or industrial use will continue to have a claim to that water. These are also called appropriative water rights. Also, really quick, to remember the water rights: riparian, river.
Just around the river bend. Just around the river bend.
Rivers are rippin' and roarin', they're riparian. River, riparian. Littoral rights: literally a pond, literally a lake, literally still a lake. Prior appropriation:
I was there first.
Finders keepers.
I already used it. Okay, that's all I got. Riparian and littoral rights run with the property and aren't sold separately. Where prior appropriation is used, water rights may be transferred away from the property. California law uses a combination of riparian rights and prior appropriation. Landowners with riparian rights don't need permission or license to exercise their right. They may use a share of the water that flows past their property, but may not divert or store it. Landowners seeking rights to water that's subject to prior appropriation must follow a permitting process. Landowners have the right to use percolating groundwater as long as it's put to reasonable use. In most parts of the state, no permit is required. Special categories of land. California defines 6 types of land considered natural hazard zones. If the property is located in one of these zones, the transaction requires disclosure of that fact. The 6 natural hazard zones are: Special Flood Hazard Area, as identified by the Federal Emergency Management Agency, FEMA. Area of potential flooding due to dam failure. High Fire Hazard Severity Zone, as identified by local agencies. Forest fire hazard area, as identified by the State Board of Forestry and Fire Protection, where fire protection services may not exist. Earthquake fault zones, as identified by state geologist maps. Seismic hazard zones, as identified by state geologist maps, which include the potential for landslide or liquefaction from earthquakes. Alquist-Priolo Earthquake Fault Zoning Act. This act prohibits building on fault lines, requires disclosures to purchasers of dwellings in earthquake fault areas, and sets requirements for permitting projects when retrofitting existing dwellings in these areas. This act is applicable to any project intended for human dwelling within an earthquake fault zone. California regulations limiting development in environmentally sensitive areas. California Environmental Quality Act, CEQA, requires an environmental review before approving development projects that may impact the environment. This applies to all projects requiring governmental discretionary review. California Coastal Act establishes environmental protections for development near coastal areas and wetlands and protects public access to beaches and waterways. Rangeland, Grazing Land, and Grassland Protection Act protects California's rangeland, grazing land, and grassland through the use of conservation easements and prevention of the conversion of rangeland, grazing land, and grassland to non-agricultural uses. That is land use. If you want more full study guides like this, subscribe and turn on notifications. Your next lesson is waiting. Go watch it now.